Simone Addison was 41 years old, and for 9 years she had let her husband believe he was the most important professional in their household. He had not asked her to let him believe this. He had simply assumed it, the way certain men assume the things that have never been challenged, and she had never found a reason to correct him because the assumption had never cost her anything she was not willing to pay. His name was Derek Addison. He was a regional vice president at a commercial insurance firm in Philadelphia, well compensated and well regarded and genuinely skilled at what he did, and none of that made what he did to her at the end of their marriage any less calculated. To the people in Derek's professional world, Simone was the quiet wife. She wore modest clothes and kept a modest car and attended his work events when invited and said the right things and left early. Because she had an early morning, which was always true and which nobody ever thought to ask about. His colleagues described her as pleasant. His supervisor had once described her, at a firm dinner Simone did not know she had been the subject of, as the kind of woman who supports her husband's success from the background. He had meant it as a compliment. She had heard about it third hand and noted it and moved on. She had, at that moment, been the managing partner of a healthcare technology consulting firm that she had built from a single client contract into a company with 41 employees and $52 million in annual revenue. None of Derek's colleagues knew this. Derek knew she ran a consulting practice. He had simply never asked what it was worth. When he filed for divorce and attempted to claim a 50% interest in the firm as a marital asset, he hired a litigation team from one of Philadelphia's larger commercial law practices. It was a sophisticated choice. The firm was genuinely capable. It had handled significant commercial disputes and had a track record that Derek's own attorney, a divorce specialist who had been confident in the choice, presented as a substantial advantage. What none of them had verified, in their understandable rush to assemble an aggressive legal strategy, was the firm's existing client roster. The senior partner who walked into the mediation conference room 3 weeks later looked at Simone sitting at the head of the table, looked at the retainer agreement on his desk, and said the 6 words that ended Derek's claim before it had formally begun. "We work for her. We always have." Before we jump into the story, comment where in the world you are watching from, and subscribe because tomorrow's story is one you need to hear. The morning light in Simone's home office came through the north-facing window at the angle she had specifically chosen when she converted the second bedroom into a workspace 12 years ago. Before the marriage, before the firm had more than 3 clients and a rented co-working desk. She had moved a wall to get the window positioned correctly and had done the drywall finishing herself over a weekend, not because she had to, but because she had always found that understanding how a thing was built was the best way to understand whether it would hold. The window let the morning light in flat, and even the way a photographer's light was supposed to arrive, without shadow and without drama, and she had worked in that light every morning since. She was a management consultant. More precisely, she was the founder and managing partner of Addison Health Advisors, which was the name on the letterhead and the name on the retainer agreements and the name on the leases for the 2 offices in Philadelphia and the satellite office in Baltimore, and which was not the name she used when Derek's colleagues asked what she did. She said she ran a small consulting practice, which was accurate in the way that a river is a small amount of water. And she had never felt the need to say more than that, because no one had asked more than that. Her grandmother, who had run a home health aid referral network in West Philadelphia for 20 years before selling it and using the proceeds to put 3 grandchildren through college, had told Simone when she was 16 years old and watching her fold letters into envelopes for a client mailing, "Simone, the ones who underestimate you are doing you the most useful favor they can. They stop watching. and when they stop watching, you can work. She had paused over the envelope folding and looked at Simone with a directness that characterized everything she said. Let them stop watching. Simone had let them stop watching. She had met Derek at a healthcare industry conference in her third year of consulting, a 2-day event in Philadelphia focused on technology integration in health systems, which was her primary practice area and which Derek had attended because his firm insured 3 regional hospital networks. He had asked her an intelligent question about risk allocation in vendor contracts and had listened with genuine attention to her answer, which she had found unusual enough to remember. They had dinner that evening and dated for a year and married in the fall. And for the first 4 years of the marriage, the relationship had been, if not exceptional, honest in the ways that mattered. The dishonesty had arrived incrementally, as it always did, and she had noted each increment the way she noted discrepancies in client deliverables, with documentation, without drama, waiting for the complete picture before drawing conclusions. She had planted a small herb garden on the windowsill of the home office the year they married, rosemary and thyme and one stubborn mint that spread beyond its container no matter how often she cut it back. She maintained it every morning before she started work, a 2-minute task that cost her nothing and that she had always found useful as a way of beginning the day with something that responded to attention. The mint, she had noticed, always grew back strongest exactly where she had cut it. The incoming signal had been a change in Derek's interest in the firm. Not curiosity exactly, but something more pointed, more acquisitive. He had begun asking questions in the last 2 years of the marriage that were different in texture from the questions he had asked before. Not what are you working on, but how many clients do you have? Not how was your day, but how large is the retainer? Not are you enjoying the work, but what does the firm actually generate? She had answered accurately and without elaboration, which was her practice, and she had noted the shift in his questioning and added it to the folder she maintained for things that needed more information before they had a name. The name arrived through a phone-left face up on the kitchen counter. Derek had been on a call when she walked into the kitchen on a Saturday morning, and he had set the phone down without ending the call, screen facing up, and gone to get something from the refrigerator. The call was still active. She did not listen to it. She looked at the contact name visible on the screen, which was not a name she recognized, and she looked at the duration of the call, which was 43 minutes. And she took a photograph of the screen with the care and precision of a woman who had been documenting things professionally for 15 years. She went back to her office. She made a note. She had found it through the contact name, which she traced through a professional database to a commercial litigation attorney in Cherry Hill whose practice focused on business valuation disputes and marital asset claims. She found this through a public bar directory and a cross-reference with the attorney's published case history. And she did it on a Sunday afternoon while Derek was watching a game in the living room, and she did it with the same calm professional attention she brought to any research task her clients required. Her face remained perfectly calm. Her hands did not shake. She moved with the same deliberate calm that had always defined her. She went back further. She pulled 3 months of Derek's personal email through the shared account administrator access he had set up during a household financial consolidation 2 years prior and apparently never revisited. She found 11 emails with the Cherry Hill attorney's office address in the header over a period of 9 weeks, the earliest sent 6 weeks before the questions about the firm's revenue had begun. The subject lines were professional and vague in the way that subject lines are vague when the sender is aware that content matters more than label. He had been consulting with a marital asset litigator for 2 months before he had asked her the first pointed question about the firm's size. She built the timeline on a spreadsheet she titled Client Research Internal, which was the kind of label that communicated nothing to anyone who was not looking for it. She pulled every piece of documentation she had on Addison Health Advisors' corporate structure, the founding date, the premarital capitalization records, the separate business account history, the shareholder agreement she had signed with herself when she incorporated, the retainer agreements dating back to the firm's first year of operation, and the most recent independent valuation, which had been completed 4 months prior for a bank lending review and which placed the firm's worth at $52 million. The firm had been founded 3 years before she met Derek. Every dollar of its initial capitalization had come from her own premarital savings and a loan from her grandmother that had been documented and repaid in full within 18 months. Not 1 cent of joint marital money had ever been deposited into its accounts. She had maintained this separation with the deliberateness of a woman who understood, from her grandmother's example, that the most important protection for anything you had built was a clean record of how you had built it. She opened a folder on her laptop. She named it Addison, D, Valuation Defense. She picked up her phone and called Patricia Osai. The ones who underestimate you are doing you a favor. Every business she had ever built started with someone underestimating what she was capable of. Patricia Osai had practiced commercial and family law in Philadelphia for 23 years and had the unhurried, comprehensive manner of someone who had seen most versions of most disputes and found this particular one, upon reviewing the valuation defense folder, notably well documented. She said, when she finished, the premarital founding date is the first wall. The capitalization records are the second. The shareholder agreement is the third. The complete absence of joint funds in any account associated with the firm is the fourth. She looked at Simone across the desk. He has no ground to stand on. But he has hired someone who doesn't know that yet. Simone said, he hired the Cherry Hill firm. Patricia said, Masson and Kelly. Simone said, yes. Patricia was quiet for a moment. Then she said, he hired Masson and Kelly to come after Addison Health Advisors. Simone said, that's correct. Patricia set down her pen and looked at her client with the expression of someone who has just understood something that changes the shape of the conversation. She said, Addison Health Advisors is on Masson and Kelly's current retainer list. Simone said, they've been our outside counsel on vendor contract disputes for 4 years. Patricia was quiet for another moment. Then she said, in the measured, precise tone she used when a situation had resolved itself in an unexpected direction, he hired the firm you employ to come after you. Simone said, he did. Patricia said, he doesn't know this. Simone said, no one checked. Patricia set her hands flat on the desk and said, that creates a conflict of interest that disqualifies them from representing adverse interests against you. The moment the conflict surfaces in a formal proceeding, his entire legal team is compromised. He will need to start over. She paused. This is not a small problem for him. Simone said, I know. She drove afterward to her grandmother's old apartment in West Philadelphia, which her cousin now occupied, and which had the particular quality of places that have been inhabited by a strong presence for long enough that the presence remains even after the person has gone. Her cousin Yvette was home and made tea without being asked, and sat across from Simone at the kitchen table where their grandmother had sat for 20 years. Simone told her what was happening. Yvette listened the way the women in their family had always listened, without interruption, without performance, with the full weight of her attention. When Simone finished, Yvette was quiet for a moment. Then she said, Grandma would have said he brought a blade to a room where you keep the sharpening stone. Simone thought about that. Then she said, that's about right. Yvette said, she also would have said that the best defense is a clean record, and you've clearly had that covered for a long time. Simone said, since before I met him. Yvette said, then this was always going to end this way. He just didn't know the ending yet. The counter-evidence that Patricia developed over the following 2 weeks completed what the conflict of interest had already structurally damaged. Derek's claim rested on the argument that Simone had used marital time, which in his framing meant evenings and weekends during which household obligations had been shared, to build the firm during the marriage, and that this constituted a marital contribution entitling him to an equitable share of its appreciation. This argument had legal precedent in some jurisdictions. It required, however, the absence of a clean premarital capitalization record, which Simone had, and the presence of some demonstrable commingling of marital resources, which she also did not have. Patricia's review found something additional. Derek had, in the previous 3 years, charged $29,000 in what his personal card described as business development expenses to a joint credit card they had maintained for travel. Patricia's team Cross referenced each charge against any client relationship Derek had developed in that period and found that 11 of the charges, totaling $18,400, corresponded to dates and locations that did not align with any client meetings in his firm's calendar. The charges aligned when Patricia ran the dates through Simone's joint account records with the same pattern of weekend absences Derek had explained as industry conferences. He had not been at conferences. Patricia filed the supporting documentation as exhibit material in the conflict disclosure motion. She noted, with the professional restraint of a woman who chose her language carefully, that the discovery of additional undisclosed personal expenditures through joint marital accounts would be relevant to the court's assessment of equitable distribution regardless of the outcome on the company valuation question. Derek spent the following weekend making calls to establish a new legal team. His original attorney had withdrawn following the conflict disclosure. The Cherry Hill firm had issued a formal notice of representation cessation. The situation had not been covered in any version of the exit plan he had apparently built. That same weekend, Simone went home and watered her herb garden on the windowsill and made dinner and moved through the house they still technically shared with the calm and methodical attention of a woman who had finished most of the important work and was waiting for the formal occasion to confirm what had already been decided. He was performing for an audience that had already filed the conflict motion and moved on. Some things you build quietly. The record does the speaking. The formal mediation was held at Patricia's offices on a Thursday morning in March, 6 weeks after the conflict disclosure had been filed, and Derek's legal strategy had been reconstructed from scratch with a smaller and less experienced firm than the one he had originally assembled. Derek arrived with his new attorney, a competent woman who had been given the complete file only 10 days prior and whose preparation, under the circumstances, reflected the time she'd had. Derek had the controlled, alert posture of a man who had experienced a significant setback and had decided to treat what followed as a test of composure. Simone was already seated at the head of the table when he arrived, which was the correct position for the person whose company was the subject of the proceeding. Patricia placed the founding documents first. Premarital date. Premarital capitalization. Her grandmother's loan, documented and repaid. The initial shareholder agreement. The complete absence of joint funds in any company account from founding through the present date. She placed the most recent independent valuation second. $52 million. Commissioned 4 months prior for a routine banking review with no connection to the divorce proceedings, which made it the most credible number in the room. She placed the $18,400 in undisclosed personal expenditures third. 11 charges. Dates, locations, the discrepancy with Derek's stated conference schedule, the alignment with joint account withdrawal patterns, She placed the conflict disclosure documentation fourth, not because it was the most legally significant element, but because it was the most structurally complete account of what had happened when Derek had attempted to use a law firm that Simone's company employed as outside counsel to come after Simone's company. The document was clean and precise, and it told, in the language of bar ethics and attorney fiduciary obligations, the story of a man who had not done his homework. Derek's attorney reviewed each document set without speaking. She wrote notes in the margins of her legal pad with the focused attention of a woman working to understand a situation she had been handed incomplete. Derek watched Simone across the table with the expression of a man revising a calculation in real time. He said, after a long pause, "You knew about the conflict before we filed." Simone said, "I knew about the conflict when I hired Patricia." He said, "You let us proceed." She said, "You were the one who chose not to run a conflict check." He tried once more. He said, "Simone, we spent 9 years together. I'm not asking for anything that isn't fair." She looked at him with the full, unhurried attention she brought to every professional situation that required accuracy rather than speed. She said, "You hired a litigation team to claim 50% of a company I built before I met you, using money I earned before I met you, through work I did before I met you, and you hired that team from the firm I employed to protect that company. And then you ask me about fairness." She kept her hands flat on the table. "Derek, the records have been available since before we were married. You chose never to look at them. That choice belongs to you." She placed the settlement terms in front of his attorney. The terms were comprehensive and unambiguous. Zero equity claim by Derek Addison in Addison Health Advisors on the grounds of complete premarital founding, capitalization, and separate maintenance throughout the marriage. Full accounting of the $18,400 in undisclosed joint credit expenditures, with repayment from Derek's share of the marital liquid assets. Standard equitable distribution of genuinely joint marital assets at fair market value. A clause, standard in Patricia's settlement agreements, requiring both parties to refrain from any public characterization of the proceedings that misrepresented the outcome. His attorney reviewed the terms for 11 minutes. She conferred quietly with Derek for 4 more. Then she placed her pen on the paper. He signed without looking at Simone again. Patricia gathered the documents. The room emptied with the particular efficiency of a meeting that had concluded exactly as the evidence had always suggested it would. Simone stood, collected her portfolio from the chair beside her, and said to Patricia, quietly, "Thursday works for the follow-up call." Then she walked out. 14 months later, Simone sat in her home office in the early morning, the north-facing window letting in the flat, even light she had placed it to catch, her coffee beside her. The herb garden on the sill just beginning its spring growth after the winter. The rosemary had come back full. The thyme was slow but reliable. The mint, as always, was already beyond its container. She had let it go this year. She found she did not mind. The firm had, in the 14 months since the settlement, added 6 new clients, expanded the Baltimore office to a full-time staff of 12, and completed the first phase of a healthcare technology assessment engagement for a regional hospital system that represented the largest single contract in the company's history. The current independent valuation, updated for the bank's annual review, placed the firm at $67 million. She noted this in her quarterly summary with the same precision she applied to every number that passed through her hands, and moved on to the next line. She had heard, through a former mutual colleague, that Derek had left his insurance firm in the fall. The details were described as a voluntary separation, which was one way to describe what happened when a person's professional credibility had been associated in several industry conversations with an ethics disclosure arising from an attorney conflict that bore his name. He was consulting independently now at a reduced rate in a smaller market. His mother had called Simone twice since the settlement. The calls were warm and gracious and made no reference to Derek and asked only after Simone's health and the firm, which his mother had apparently at some point come to understand was a significant thing. Simone had taken both calls with genuine warmth and had wished her well and had meant it. Andre Pemberton was an information systems consultant she had met at a health technology conference in the fall. A thoughtful, unhurried man who had spent 20 years in large system implementations and who had asked her at the conference reception about the methodology her firm used for technology assessment, with the specific interest of someone who had read her work before they met. She had found the preparation impressive. They had dinner that evening and again the following month, and had fallen into a rhythm that suited them both, which was to say the rhythm required no performance from either party and produced, most evenings, a quality of company she had not expected to find this quickly. She was not in a hurry. She never had been. The mint on the windowsill had spread to the small clay pot beside it that had been empty since December, and she had not yet decided whether to let it or trim it back. She looked at it in the morning light and thought about her grandmother folding letters at the kitchen table and saying that the ones who underestimate you are doing you the most useful favor they can. She thought about Derek's litigation team walking into a conference room to go after a company that employed them and not knowing until they got there. She thought about the record she had kept for 15 years, clean and documented and entirely sound. She had built everything quietly. The record had done the speaking. She was free. She was solvent. She was unbothered. The mint grew where it was going to grow. She poured her coffee and turned to the work. I hope you enjoyed that one. Be sure to like the video and subscribe so you don't miss the next story. I've picked out 2 more for you that I think you'll really like.